Chapter 7, Part 1. There are two parts to Chapter 7 for a number of reasons. The, uh, the most important one is that this is probably the most intensive chapter uh, of them all. It is not a coincidence that this comes right after the discussion of stress and labor relations, because when the police officer sort of graduates from the academy and makes it out onto the street, they now have to apply all the law that is required, and they're really not allowed to make any mistakes. The police get the law from statutes, from case law, from the constitutions, the state constitutions, and the U.S. Constitution. And so what we're going to do is we're going to go through really in two stages the laws that they have to follow and that they have to apply, and they have to apply almost perfectly. We sometimes compare police officers to brain surgeons because they're really not allowed to make any mistakes. So I'm asking you that as you listen to this lecture and you read this chapter, I'm hoping that you're going to read it with an eye towards thinking about how easy or how hard it would be for a police officer to keep up with all of this and to do it all correctly without making any mistakes. It's broken up into two sections, as I indicated. The first section is going to be talking about sort of law generally, but also talking about Fourth Amendment of the Constitution and its protection against unreasonable searches and seizures. We're going to spend a fair bit about that along that. During this lecture, there will be two or three stopping points where there will be either a case or a comment that I'm going to put out for you to respond to. So I want you to pay attention for that. So the first section is Fourth Amendment, and then the second section is going to be both the Fifth and Sixth Amendments of the U.S. Constitution, and specifically the rights to counsel under each of those. And as we go along, you'll kind of see why each of those are important and why they're different. And I will suggest to you that if you spend the time with this chapter, to the extent that all of this makes sense to you, what you're going to find is that you actually know more about the law than most lawyers and most police officers. So we're going to do some share screen here. I'm going to bring up the slide deck, and we're going to speak off of the slide deck. So let's have a look at that. Yep. We talk generally about the rule of law. There are three principles that establish the rule of law. There's absolute supremacy or predominance of regular law rather than arbitrary law. In other words, the idea behind that is that in the United States, different from other systems of justice or other countries, the law is ascertainable. You can find it. You should be able to any law that we make that we say exists, you should be able to find relatively easily. And we'll have some conversation about how you find locate the law. The other assumption that we have in our system is that everyone is equal before the law. In other words, they're supposed to be treated equally under the law. Now, that's a conversation that we can have for a very long time about whether or not that actually exists in the United States. I will say that it is an ideal. It's something that we strive for. I think it's fairly clear that we probably aren't as good at that as we should be, and it's something to think about in terms of how we would want to get better at it. The U.S. Constitution, and this gets a little bit complicated, but the U.S. Constitution is not the law in and of unto itself. It's actually a reflection of the laws that we believe exists as a function of being a democratic government. And probably the most important about aspect of that I want to have some conversation about um, is those amendments. We always talk about the different amendments to the Constitution, but those first initial amendments that were passed at the same time as the Constitution is known as the Bill of Rights. The Bill of Rights are really, really important. When the framers of the Constitution um, decided to construct the democratic government, they did a really pretty good job of deciding how the democratic form of government should be constructed. Then it occurred fairly late in the process that that rule by the majority could sometimes not be in the best interest of people. And the example that I'm trying to make is, let's say a particular state decides that they want to uh, put to vote to the people of the state whether or not to bring back slavery. Well, we should kind of all understand that that's not allowed, right? Even if the majority of the people in the country wanted to bring back slavery, the law of the land, no matter what the people want, the law of the land would say that that's not allowed, right? And that's one of the amendments to the Bill of Rights. The right to free assembly, the right to the freedom of religion, free speech, the right to bear arms, the Fourth Amendment right against unreasonable searches and seizures, right? The right to have a jury trial if you are charged with a jailable offense, the right to have counsel present if you are subjected to criminal charges. All of those kinds of rights are rights that exist in the Bill of Rights, and they exist to protect the individual against the tyranny of the majority or the tyranny of the state. Right. So the Bill of Rights are rights that cannot be violated, even if they're popular, even if the government wanted and the people voted that it would be a good idea to make a particular religion the religion of the United States. The Bill of Rights would say that's not allowed, not possible. And that's why we spend a lot of time talking about the Bill of Rights, because it's extremely important for not only for us to understand, but for police to understand, right? So this is the conversation that we have with the police all the time, which is that it should be as important to the police to protect those rights as it is to the individual to want to be protected by those rights. Right? It's what separates us from other forms of justice in other countries. It is intended, these rights are intended to protect the individual from the power of the state. So I want to make sure that we're really clear about this. So who are the police? The police are an arm of the executive branch. They are the enforcement arm of the executive branch. So the executive branch is supposed to um, execute the laws of the United States and the states. That means it's the police responsibility to enforce the law. But it's also the police responsibility to obey the law, right? So we'll talk about that as we go along. On the one hand, we have sort of this set of protections that the law provides, but then we're also a little bit of a dynamic legal system, right? So the laws that interpret some of the bigger concepts are dynamic. We change law all the time. How we believe certain protections should be applied. The gun laws are constantly being changed, tweaked. Reasonable restrictions on gun laws have been enacted and applied over the years. Reasonable restrictions on speech, right? So hate speech is not protected. Um, uh, the different protections for the freedom of religion, right? So we can neither uh, uh, infringe religion, but we are also not allowed to promote a particular religion, right? So there's all kinds of individual laws that are passed to sort of enforce these larger principles that are protected by the Constitution. For those of you who think that you want to be a police officer, you should already now start thinking about um, the law and how the law um, uh, decides what they can and can't do on the street. Um, the police officers who understand or keep up with the law are have a tendency to be the best police officers, right? So you want to get used to doing that. Some of you want to be lawyers for the same reason. It's a really good time for you to start thinking about what laws exist and how laws are applied and who's responsible for applying them, right? I always tell police officers that they should be carrying around a binder that includes the most recent case law, a whole bunch of concepts that they apply on a daily basis, so that they can keep up with what they're required to do and what they're not allowed to do, but also because they're going to run into people in the legal system who don't know the law. And if the police officer is up on the law and they have the physical law with them, you're more likely to get a just result. So one of the big concepts that we're talking about here uh, under the Fourth Amendment, protections against unreasonable searches and seizures, is the concept of probable cause. Now, you'll hear probable cause in a number of different scenarios. You'll see probable cause in the idea that someone has to have probable cause to arrest, right? And the idea behind probable cause is to arrest is that a police officer has to have a reasonable probability, be able to articulate there's a reasonable probability that a crime occurred, and also a reasonable probability that the defendant or the suspect had something to do with it. So that's one kind of probable cause. When a police officer wants to search your home for evidence of a crime, they're going to go to a neutral judicial officer, often called a magistrate. It can sometimes be a judge. And when they go to that neutral judicial officer, they're going to provide that officer with facts, facts that they know or facts that they can rely on. And those facts have to establish, again, probable cause that a crime occurred, probable cause that evidence um, supporting that crime is going to be found in the place that the police officer would like to search. So if they want to search my house, they're going to have to articulate to the judicial officer why they think evidence of a specific crime, not just that I'm a criminal, but of a specific crime, is located inside my house. And they have to state all of that with what we call particularity, right? They have to state it so that they can say exactly what crime they think I've committed. And they also have to state exactly what items they're looking for in my house. And then they're also going to have to state the reasons why they believe that there's reasonable probability, probable cause, reasonable probability that evidence of that crime is going to be inside my house. Right? Probable cause is more than a mere hunch, but it's also less than actual knowledge. The third kind of probable cause that we see, it's similar to the probable cause that a police officer provides to a neutral judicial officer to arrest someone, is once someone is arrested, they have a right to what they call a preliminary hearing. And it's a hearing where the judge hears a minimal amount of evidence to establish, you guessed it, probable cause, right? A reasonable probability a crime occurred and a reasonable probability that the defendant had something to do with it. If the court finds that there is a probable cause at that preliminary hearing, then the case gets pushed on or moved forward to trial. The courts look at the type and amount of probable cause the officer had at the time of the arrest. So this is really, really important. There's not a certain set amount. You will hear sometimes people say that probable cause is more likely than not. So it's 50% plus one would be probable cause. And that's actually not the law. What the law says is that probable cause is a reasonable probability that a crime occurred and a reasonable probability the defendant had something to do with it. And most importantly, that the amount of probable cause necessary varies by the circumstances. It varies by the quality of the information that the officer has. It varies by the seriousness of the offense. So it's not the same. It depends on the totality of the circumstances. There are lots of ways to define probable cause for the officer to make an arrest, but let's talk a little bit in more detail about that. It is suspicion plus facts and circumstances that would lead a reasonable person exercising ordinary caution to believe that a crime was committed or about to be committed, and that the subject of the warrant actually is the person who committed the crime, right? So what I said before, reasonable probability crime occurred, reasonable probability defendant had something to do with it. There's only one standard of probable cause, but like I said, that can vary under the circumstances depending on seriousness of the offense and the quality or the type of information that the officer has. It is also, we think of probable cause, and there's another standard that we'll be talking about is reasonable suspicion, but we have a tendency to think of that as an objective standard. It is an objective standard by the definition, but here's the tricky part. A police officer can have probable cause both because of, like I said, the quality of the information that they have, but that's also through the lens of the training and experience of the police officer. So a police officer with a whole lot of or many years of experience would constitute probable cause to them, or what facts that are meaningful to an experienced police officer may be different than those same facts when they are confronted by a rookie or an officer that has very little information. So oftentimes as a judge, what I'm doing is I'm listening very closely to what the training experience of the police officer is, and why that training experience is meaningful in the police officer's interpretation of the facts that they have before them. Because that does, I call it an objective subjective standard. The standard is objective, but the lens that the evidence is viewed through is subjective. It depends on the training and experience of the police officer. So let's back up a little bit and talk about the Fourth Amendment. It is intended to limit overzealous behavior by the police. And now I can't emphasize enough how important this is for you, the student, to wrap your head around. Is the Fourth Amendment does not protect the individual from all searches and seizures. They protect the individual from unreasonable searches and seizures, right? Part of that definition of unreasonable includes intentional misbehavior by the police. That's the easy one. Intentional misbehavior by the police that's intended to obtain evidence. That's always going to be in violation of the Fourth Amendment prohibition against unreasonable searches and seizures. But because we have that rule that the Constitution, the Fourth Amendment, protects against unreasonable searches and seizures, that sort of drives why we have certain aspects of our justice system. So arrests, unless they're committed in front of the officer where the officer actually sees it, and there's some exceptions to that, but generally speaking, arrests require warrants. In other words, the police officer has to go before that neutral judicial officer and present the evidence to that neutral officer for the neutral officer to decide that the defendant should in fact be arrested. And if they do, then they issue what's called a warrant. The physical piece of paper is called a warrant. It's issued by that neutral judicial officer. And like I said, sometimes that's called a magistrate. The Fourth Amendment balances individuals' right to privacy with the government's right or obligation to search, right? You want to live in a country where the police are active and active to capture people who actually break the law. We don't want to support the police going after people who have not broken the law, right? So when the police officer goes before a magistrate, they're going to need to provide objective facts as to why they think the law has actually been broken and why the defendant had something to do with it. They're establishing that reasonableness of the warrant. As I indicated, it protects against unreasonable searches and seizures. It's also, and this is really important, all seizures in the United States are deemed to be unreasonable per se. That's another fancy way of saying is that unless the state provides a reason why they believe that they weren't required to get a warrant to search a house, warrants are required. Warrants are required across the board. There are exceptions to that rule, but they're required. In other words, if the officer goes and searches something without a warrant, that search is deemed to be unreasonable unless the state can put on evidence as to why they didn't need a warrant, what the exceptions are. And we'll talk about what those exceptions are. So what we're talking about is at the end of this slide is the warrantless clause. No warrant shall issue but upon probable cause supported by oath or affirmation. And remember, I said earlier, the officer has to state with particularity the place to be searched and the people or things to be seized. Right? So that's required. Now, most of you have probably heard of what we call the exclusionary rule. If you were to look in the Constitution, the exclusionary rule does not exist in the Constitution. It doesn't. You can look all you want, it's not there. The exclusionary rule came along in the early 60s, and it came along in the early 60s because, as Steve Bamford told you, in the history of policing, police in the early 1900s up to about the early 1960s, technology kicked in, and the police had gotten better and better and better at using technology to investigate crime. And there was a concern, not sure at the time whether that concern was evidence informed concern, but it was a concern. The concern was that the police had gotten so good at what they did that they had improved their abilities to obtain evidence against people illegally in violation of the Constitution. So the U.S. Supreme Court in Mapp versus Ohio specifically said that if the police engage in misconduct, intentional misconduct, and the purpose of that misconduct was to obtain evidence against the individual, that evidence is excluded from trial. So the police officers, if they violate the Constitution, you cannot use the evidence that they obtained in violation of the Constitution against a defendant in the court of law. Now, keep in mind, that's a cost-benefit decision, right? There's going to be true criminals out there who will get away with their crime because the police didn't do it the way they were supposed to do it. Because that evidence then gets excluded, can't be used against the defendant, and the defendant goes free. So we have a system where unless the police do it the right way, that evidence cannot be used no matter how criminal the defendant actually is. Right? So That's the rule that we have. Now, it is very important for you to focus on this idea of the exclusionary rule not being in the Constitution, and B, it's limited to intentional police misconduct. It doesn't apply to police officers who make mistakes. It doesn't apply to mere negligence on the part of the police officer that negligence results in obtaining evidence against the defendant. It only applies to intentional misconduct on the part of the police that results in evidence against the defendant. We talked a little bit about arrests. Again, in the United States, we sort of rule that if you arrest someone and you hold them, we take them and put them in jail pre-trial. We're going to have this hearing, this what I call the preliminary hearing, where the police officer is going to have to put on some minimal amount of evidence to be able to justify the defendant continuing to be held. Sufficient evidence to show that it's reasonable probability crime occurred and reasonable probability the defendant had something to do with it. We have a fancy term for how people can get released. It's called a writ of habeas corpus. Lawyers file them all the time that says my client's being held and my client's being held unlawfully. And then a hearing is held. The lawyer puts on the evidence as to why they think their client is being held unlawfully, and then the state has to respond. If the state can't provide a proper response, then the defendant gets released. We talked about the arrest with a warrant. Officers should obtain warrants when making felony arrests if there are no exigent circumstances. So I said there's exceptions to the warrant requirement for arrests. There's a laundry list of exceptions. And we'll talk a little bit about them. That's not as important other than for you to know that generally speaking, warrants are important and they should get a warrant. But there are also exceptions, or what we call exigent circumstances. When an officer goes to get a warrant, the officer is put under oath. They're swearing that the information that they have is true and accurate, either because they observed it themselves or that information was provided to someone and the officer believes that information for some particular reason. Why is it that the officer believes that information? Well, it was given to them by another police officer who did see what happened, or it was given by a citizen, provided sufficient information about how they came to possess the information that makes them reliable. Or the police officer used what we call an undercover informant who has been used before and found to be reliable. As I indicated, neutral magistrate issues the arrest warrant if they agree that the probable cause exists. Warrantless arrests do exist, but they still require probable cause, right? Street officers rarely have the time or the opportunity to effect arrest with a warrant in hand. So they can watch, they can see it occur. Warrantless arrests of offense not committed in your presence. There are most felonies, you can make an arrest outside of the presence, again, if you can establish why you believe the information that you received. Misdemeanors is a narrower set of circumstances that you can make a warrantless arrest on a misdemeanor. There's different states. Virginia has a statute that has sort of a laundry list of offenses that the police officer can make an arrest without actually observing the misdemeanor take place. Just know that that exists. You see on TV all the time, police officers picking people up on the street and taking them into the station and interrogating them. And with the idea that, well, Joe Smith told me that they think he's involved, so they go scoop him up and take him into the police station and interrogate him. In the United States, that's actually not legal, right? The police officer can't just pick you up and take you to the station and interrogate you. You can agree to, and lots of people agree to go to be interviewed by the police, but if the police are going to actually put hands on you, seize you, and take you to the police station, they're going to have probable cause that you're involved in a crime. Similarly, police may not randomly stop a single vehicle to check license and registration without reasonable suspicion for stopping the driver. And we'll talk about the definition of reasonable suspicion in just a bit. But the concept that you want to make sure that it's clear in your head. The police officer can't randomly pull people over. They have to have a reason to believe that in whatever car that they're pulling over is involved in some violation of the law. Again, there's some exceptions. One of those is checkpoints. The checkpoint is an exception because it is a pre-approved plan to pull cars over, and normally it's the location that's selected is a location where there's been a history of DUI or there's been a history of crime in that area, and that plan to pull vehicles over is approved, and the police officer on the street who's actually doing the pulling over has no discretion. They're either pulling every single vehicle over or they're pulling every fifth vehicle over, but they can't pick and choose randomly who they pick, right? Or as we see in the real world, if you leave it up to the officer to decide who they pick, they're going to pick the person that they think, based on their own internal biases or prejudices, they're going to pick the person that they think is most likely to be guilty. And unfortunately, that has a tendency to be people of color. So that's why we have a rule that says they can't do it that way. They either got to pull over every single person or every third person or every fifth person. And if they have all those things in place, then you can pull people over in the checkpoints. Like I said, similarly, police officer pulls over a vehicle and there's 5 people in the vehicle. The driver consents to the car being searched. Police officer finds drugs inside the center console with a top on it. No one in the car admits to possession of the drugs. The law allows the police officer to arrest. They have probable cause to arrest all 5 people in the car. But unless the police officer has something more that localizes who in the car that drugs actually belong to, they can't convict beyond a reasonable doubt any one of the 5. So that's something that probably bears repeating. The police officer can arrest all 5 people in the car, but if the police officer doesn't obtain any additional evidence that localizes among the 5 who the drugs actually belong to, by the time they come to court for trial, police officer doesn't have enough evidence to convict anyone beyond a reasonable doubt. As I stated previously, a person who's arrested without a warrant is going to be entitled to a very quick hearing in front of a judge for the judge to decide whether or not they should continue to be held. All right. There's lots of classes that we do where we talk about police citizen encounters and what is a consensual encounter where the police just walk up and says, "Excuse me, sir, do you mind if I talk to you for a few minutes?" And how those initial consensual encounters can change or morph into something else. They morph into some type of seizure. When a police officer pulls you over for speeding, that is a seizure. People get confused by that because it happens so often. People pull people over to give them a speeding ticket. That is a seizure. It is under the Constitution, but is also been deemed a reasonable seizure. And the reason why is because it's normally limited in scope. And the police officer has to either give you the ticket or let you go. They can't mess around and spend any time longer than the time necessary to either give you a warning or to give you the ticket. It is a seizure. Under Terry versus Ohio, this is what we call a Terry stop. Limited stop for the limited purpose of either giving a ticket or giving a warning and then letting someone go, right? And this is probably going to be the sort of one of the stopping points in when you watch this lecture. And I want you to think about what kinds of stops when you stop someone for a speeding ticket, what could happen at that interaction between the police officer and the operator of the vehicle that makes this something more than just a Terry stop or a traffic stop. What could happen that could make it into a full-blown reasonable suspicion stop to investigate a crime. So think about that. I'm going to ask you to respond to a couple of prompts on that as we go along. First of all, there's no rule that determines the point of seizure in all situations. The standard is whether suspect believes his or her liberty is restrained or not free to leave. So we just had a trial yesterday where police officer walks up to a car because the person's asleep behind the wheel. They knock on the window, the person doesn't answer. They knock on the window, the person doesn't answer. They knock on the window, the person then answers, and the police officer says, are you okay? And the guy says, yeah, I'm okay. He goes, so once you unroll the window, he unrolls the window, and then the officer smells odor alcohol. He asks the defendant to get out. The defendant then refuses 4 or 5 times to step out of the car. The officer says, if you don't step out of the car, I'm going to pull you out of the car. At that point, that's where the seizure occurs, right? Where the officer actually lays hand on the door to open the door to pull the defendant out. Now it's not a walk up and chatting with the person. That point where he's physically going to remove the defendant, you're now at a seizure. Now, probable cause, reasonable suspicion. Just so you folks know, is I teach all over the place. I teach new judges search and seizure law. And one of the things that I do is I go and I look at all the cases that involve suppression that have occurred over the last year. And I'm looking for trends. I'm looking to see like what subject matter comes up most frequently in the appellate courts. In other words, so they're asking an appellate court to review a trial court's determinations of the law. And far above the most common areas that make it to the courts of appeals for consideration is deciding whether or not there was reasonable suspicion and deciding whether or not there was probable cause. Reasonable suspicion to stop the defendant, probable cause to arrest the defendant. And as I indicated previously, the best way for the police to search person or premises is with a search warrant. We over and over and over tell police officers, if you can get a warrant, do so. Even if you think there's an exception. If you've got the time to go get a warrant, you want to go get the warrant. And the reason why is because all warrants are deemed to be unreasonable unless the state can provide evidence to establish why it was in fact reasonable. So you really want the police officer to err on the side of getting warrants. Sometimes we'll see police officers who will say, I don't think I need a warrant here, but I can just have an officer stand right here and we're going to call in a warrant and go ahead and get it. That's a good practice. As I indicated, magistrates receive information from a sworn affiant, determines that probable cause exists to believe that evidence is possessed, and they issue the search warrant. Now we're talking a little bit about some of the exceptions. Police may enter a home without a warrant if they reasonably believe an occupant is or is about to be seriously injured. So you can think about situations where police get called when they arrive at the scene, an occupant of the home is in the street. They say that someone's inside the house, they have a gun, and that they're threatening to kill other occupants inside the house, and they've heard gunshots, right? At that point, the police officer isn't going to have to go get a search warrant. They're going to be able to go into the house to see whether or not anyone has been injured. They do not need ironclad proof of a likely serious life-threatening injury to invoke the emergency aid exception, right? So they don't need to say to the person on the street, well, you got to provide me some proof before I'm going to go in and look for people who might be shot. They can say, hey, that person said there might be someone in their shop. That's going to be good enough for them to go in without a warrant. We see this in the drug investigation world all the time where they're knocking on the door and then the officers hear certain sounds that are consistent with the occupants trying to destroy evidence. The most common one is the flushing of the toilet, right? They're putting drugs in the toilet, flushing the toilet. The officer hears all the toilets in the house being flushed. They get to go in without getting a warrant. Other exceptions to the exclusionary rule what they call the public safety exception. I don't want you to get too wound up about this, but there are situations, and the sort of classic example is where um, a crime is committed that involves the use of a firearm, and the location of where the shooting occurred is right beside a playground. And when the suspect is located by the police on the other side of the playground, the suspect is not in possession of the firearm. The police can forego really all of the rules and say, I'm not going to ask you anything about what you did in terms of the shooting. That firearm is probably somewhere on the playground. Little kid's going to end up killing themselves. You got to tell me where the gun is. And what I mean by that is that they're going to interrogate them. They're going to be in custody. There's not going to be a Miranda rights read. There's going to be they're going to be seized. There's all kinds of rules being broken that are an exception to the exclusionary rule for the public safety exception. They just want to get the gun. So when you're listening, you want to listen to only those questions that are aimed at trying to find the gun, and not any questions that are aimed at solving the crime. There's inevitable discovery exception, which is the police were well on the way of doing what was necessary to find the evidence that was illegally seized. And just because the police found it sooner or even used techniques that were not allowed, if you can show that they were eventually going to find it using legal means, then it's okay. Good faith exception, we're talking about a situation where a police officer does go and gets a warrant to search your house. Turns out the evidence or the facts that the police officer had at the time that they related to the magistrate to get the warrant, that some of those facts turn out not to be accurate. And sometimes it's not accurate just because of the breakdown in communication or how it was translated. Or sometimes it is like someone who provided the information just didn't tell the truth. But at the time that the officer provided that information to the magistrate, officer had no reason to believe that the person wasn't telling the truth. If the police officer has gone to the magistrate and gotten the warrant, the police officer has the right to rely on that warrant, right? It's intended to encourage police officers to get those search warrants. And if they do get the search warrant, even if there's some flaws in the search warrant, they have a good faith reliance on the issuance of the search warrant. If the police officer find evidence, but they're not doing anything specifically towards this defendant, they're doing something illegal related to someone else, and finds evidence against the first defendant, then the exclusionary rule doesn't apply. Types of warrantless searches incident to a lawful arrest. There's been a rule for a very long time: is if you arrest someone, you can search them incident arrest, and you can also search their wingspan, right, from fingertip to fingertip. They call it the Chimmel perimeter, right? Is everything that the defendant could touch, that area that the police could search. So if you arrest someone while they're in their vehicle, you can arrest them, and you can also search that wingspan area of the vehicle. Now, the law has evolved that also says that if the vehicle's not parked in a place where the vehicle can stay, then the police have to tow the vehicle. And if they tow the vehicle, they also have to search the vehicle so that they can establish an inventory. Searches during field interrogation. Sometimes police officers, when they pull someone over for a traffic stop, the driver is acting in a way that is consistent with them being armed and dangerous. So the police officer has the reasonable suspicion that crime occurred because they pulled him over for the traffic stop. And then they also have, or they can articulate reasons why they believe the defendant is armed and dangerous. They can search that person for weapons only. They can search that person for weapons without having to have a warrant. As I indicated before, searches of automobiles carried out under certain circumstances. Because vehicles are easily moved, We have what's called the Carroll Doctrine, Carroll versus Ohio, which allows the police officer to search the vehicle without a warrant. Searches of evidence in plain view. The police officer gets called for a domestic disturbance while they are inside the apartment talking to the alleged victim of that. They see a heap of drugs sitting on the table. They can seize those drugs. They don't have to go get a search warrant. And then obviously probably the most obvious one is if police officers ask for consent to search and the person says yes, then consent searches are perfectly okay and they don't require a warrant. As we indicated, with searches incident to a lawful arrest, that's that Chimmel versus California, the Chimmel perimeter. We talked about the in-home protective sweep. For years and years and years, law enforcement took the position that cell phones were not did not require a search warrant to search the contents of a cell phone. As we kind of all know now, as cell phones have evolved to the point of just being essentially mini computers, right? So they contain everything about your life. And as a result of that, the U.S. Supreme Court has ruled now that cell phones, if the police officer wants to look inside, like look at the emails or the text or whatever, the contents of the phone, they have to get a search warrant to do that. Okay, so this is that prompt. Terry versus Ohio permits brief stop for questioning, pat down search of external clothing for weapons with less than traditional amount of probable cause. That's what the Terry versus Ohio case says. That deals with a situation where the officer thinks that there is criminal activity afoot. They can stop that person. And if they can articulate the reason why the person is armed and dangerous, they can pat them down for weapons. Terry versus Ohio is broader though, because Terry versus Ohio says that you can stop someone for a brief detention if you can articulate why you think criminal activity is afoot, right? So, and that's traffic stops. And it's also things that occur on the street. Officer can say why they think criminal activity is afoot, and why they think they're localizing onto a particular person, but they can only keep that person for the period of time necessary to either confirm their suspicion about the person or dispel that suspicion. So unless they can generate some additional reason that elevates it beyond just suspicion, they're going to have to let them go. There's what we call unprovoked headlong flight, right? If police officer is in a place where criminal activity, it doesn't have to be criminal activities afoot, but it could be as simple as a high crime area. And as they're walking along, someone takes off running. It's called unprovoked headlong flight. That then takes that one sort of thing, which is high crime area plus the unprovoked headlong flight, then becomes reasonable suspicion and allows the officer to chase the person down for the purpose of either confirming that suspicion or dispelling it. Officer safety, we always had these issues, and we see it on TikTok a lot, where people think that they don't have to exit the vehicle, or that they can exit the vehicle and leave. The law of the land is that if the police officer has a lawful reason for stopping the vehicle, the police officer can keep everyone in the car. They can make everyone get out of the car. They can actually cuff everyone for the officer's safety. They can prevent people from leaving. So there's 5 people in the car, and one person says, look, I just was hitching a ride and got a ride with these people. I don't know these people. I want to go. Police officer can make that person stay until the traffic stop is complete. When we talked about the sort of searches of automobiles under special circumstances, we're talking about, again, like the Carroll Doctrine, police must have enough probable cause. So it's very important. You're not allowed to search the automobile just because it's an automobile. You still have to have probable cause, the kind of probable cause necessary to get the warrant, but you don't have to get the warrant because the automobile is easily moved. Now, the laws changed a little bit about the Chumble perimeter. It used to be that you could search the entire vehicle, even if the suspect who was driving the vehicle is in custody, right? That's not the law anymore. The law is if the defendant is in custody, he's in cuffs, and he's locked in the back of the police vehicle. The only way the officer can get into that vehicle now is if they can articulate the reason why the defendant could still get to the vehicle and arm themselves, or why the officer believes that evidence relevant to the crime that the defendant was arrested on would be inside the vehicle. If the officer can't do one of those two things, the officer cannot get into that vehicle without a warrant. And as I indicated previously, if the vehicle is impounded following a lawful arrest, police may search the vehicle to inventory its contents. Going back a little bit, when we were talking about Terry versus Ohio, so I want you to read Terry versus Ohio. You're gonna see the link beside the lecture. And what you need to do is you need to copy and paste that into your URL. The case will come up. You'll get to read that, and then I want you to write a response, and the response is going to be something along the lines of what you think the limits are of Terry versus Ohio, how Terry versus Ohio reasonable suspicion could morph into something else like probable cause that a crime has occurred, what kinds of things you think happen at traffic stops that that sort of change the circumstances from a Terry stop to something more serious. We talked earlier about evidence that was observed in plain view. If the police are lawfully on the premises, they may seize items in plain view. Fences, no trespassing signs afford no expectation of privacy. In other words, if I can still see it, even though you put up a no trespassing sign and I'm not on your property to see it, then it's plain view. Police may make naked eye aerial observations of suspects' backyard or curtilage. So flyovers, like again on TV, is and well they flew over and they shouldn't have been able to see inside my backyard. That's not the law in the real world. The real world is the police officer can fly over your house and see with their naked eye evidence of a crime. Then it's not subject to suppression. And we talked about searches when consent is given. Very important. There's no law in the land that requires a police officer to advise someone that they have the right to refuse consent. Officer asks for consent. If the person says no, then the officer needs to move on. If the person says yes, then obviously they can search. But the consent to search has to be voluntary, which means you got to look at all the totality of the circumstances. At the time that the search was requested by the police, where were they? Were they on a rural road with no witnesses? Were they in the middle of an urban area where there's tons of witnesses? Were there a lot of police officers with their guns drawn? Was there just one police officer, no gun visible from where they were discussing it? When the officer asked, if the defendant says, no, I don't want you to search, is there an argument? If there's an argument and then the defendant gives in, there's a pretty good argument, no pun intended, that the waiver or the consent search is not voluntary. So you want to look at what that interaction is between the police officer. You also want to look at the circumstances of the interaction. There's one case where a woman was asked to consent to search and she had 3 little kids in the back seat of the car, and because she was worried about the kids, she kind of allowed the consent to occur, even when she originally said she didn't want them to search the vehicle. So all of those factors, totality of the circumstances, you have to look at to decide whether or not the consent was voluntary. Police cannot deceive people into believing they have a search warrant. You'll sometimes see that on TV where the police officer will say, "Hey, do you mind if I search your vehicle?" And they go, "No, I want you to search my vehicle." He goes, "Well, I've got a warrant right here in my pocket that allows me to search the vehicle." And they go, "Well, if you've got a warrant, then go ahead." Right? They can't lie about having a search warrant unless they have to actually have the search warrant. What to do if one occupant gives consent and the others object? So the rule about that is that So the driver says, yeah, you can search my whole car. If there are containers inside that car that belong to particular occupants of the vehicle, those occupants have to be given an opportunity to say whether or not that search that has been granted by the driver applies to those containers. In other words, you can't move the occupants out of the car and then talk to the driver separate and say, do you mind if I search the vehicle? The occupants have no idea that that conversation occurs. That request to search has to occur where the occupants can hear it, and so that they have an opportunity to say, hey, my backpack's back there and you can't search my backpack. If the occupant does say that, unless there's some other reason that gets the police officer into the backpack, the police officer cannot search the backpack pursuant to consent that was provided by the driver. Uh, Electronic surveillance, we're not going to spend a whole lot about that. It used to be, and this is that dynamic part of the law that we talked about. Back in the 1920s, the courts sort of consistently thought that wiretaps, where they let people listen in to your phone conversations, were not searches and seizures. So that was 1928. Then you get to 1967. 1967, guess what's just happened? It's changed, right? And they said that it is in fact a search. All right. Now, before we get to the Fifth Amendment, you don't see this in the slide, but you're going to see it in your beside here. Case I want to talk about is um, Herring versus United States. Herring versus United States is, we had stated at the very beginning of this part of the lecture when we were talking about exclusion or suppression. And we said that that's limited to intentional police misconduct that is intended to obtain evidence. Over the years, similar to how wiretapping from 1928 to 1967 goes from legal to illegal, for a very, very long period of time, we sort of took the position that if a police officer did something wrong, and when we say did something wrong, it could be intentional, it could be unintentional, it could be negligent, it could be gross negligent, but the courts really didn't distinguish any of that. What they would do is that if the police obtained evidence as a result of that misconduct, however you characterize it, then suppression was appropriate. And then along comes Herring versus the United States. And Herring says we've been confused about that. We need to back that up. And in Herring, it says, look, suppression was really only supposed to be limited to intentional police misconduct. And therefore suppression is only available for intentional police misconduct that is performed with the intention of obtaining evidence against a defendant. So now the law of the land in the United States is that unless you can establish that the police intentionally engaged in misconduct to obtain evidence against a defendant, suppression is not a remedy. I'm going to leave you with an example, and then the prompt that you have beside you is going to have you read that case. You're going to need to read it completely, and then I want you to respond to some questions about how bad does it have to get, right? So the real world example is most police officers in the United States have inside their car computers. And on those computers, they can do everything. They can look up your license plate to see whether or not you've got outstanding warrants. They can look to see whether or not you as a human being have an outstanding warrant. They can look to see whether or not you've had violent contact with the police before. They can just do a whole host of things on the computer before they actually stop you. For any of you who've ever been stopped on a traffic offense, you'll sometimes notice that the police officer will say, I saw you on block 1, but the police officer didn't actually pull you over until block 20 or 10 or whatever. And the reason why is the officer observes you, and then before they actually pull you over, they're going to run your plate. and run your background to make sure that you don't have outstanding warrants or that you don't have a history of violence or whatever. So they're going to get some information about you before they actually interact with you. In Herring, what happened was the police officer runs a plate, and on the plate says that there's an outstanding arrest warrant for the driver. So the police officer stops the vehicle, arrests the driver, and then searches the vehicle incident to arrest because the vehicle's in a place that can't be towed. The problem with all this is that the warrant for arrest for the defendant, it had been withdrawn in court the day before, and the police had not updated the computer to reflect that that warrant was no longer a valid warrant. Right. So you've got police misconduct, right? They arrested someone on a warrant that doesn't actually exist. But then the question is whether or not the evidence they found inside the vehicle is subject to suppression. And the answer to that in Herring was no, it is not a violation. And the reason why is because the police officer relied on data that was bad, and there's no reason for that officer on the street to know the data that they were relying on was bad. As a result of that, that's maybe negligence, but it certainly is not intentional misconduct on the part of the police officer. And as a result of that, suppression is not available. So read the case and answer these questions that are going to be to the right of your screen. And then this may or may not generate some questions that you have that you can send to me for me to respond at the end of my professor, or that opportunity for you to weigh in during the week for me to respond, and then I will respond back. All right, so we're now at the end of part 1 of chapter 7. And then next week, then we will do part 2 of chapter 7, which is going to be 5th and 6th Amendment rights to counsel. All right. Thank you, folks.